Considering taking that next step in your small business and opening up a physical store location? Worried about what some of the traps in your new commercial lease could be and what you should be looking out for in signing a commercial lease for your new location? Well, then this video is for you, because in this video, we'll be discussing some of the most controversial, contentious, and dangerous aspects of signing a commercial and providing lease, and sharing some information and knowledge as to what you should look out for in these clauses that we're about to discuss specifically, and questions you should be asking your lawyer when signing on to a commercial lease as a commercial tenant. Of course, here at Graphene Business Law, we are well versed with commercial leases. We've helped negotiate commercial leases of hundreds of thousands of square feet for industry leaders, and of course, brand new startups and entrepreneurs starting off with even the smallest of spaces, because the legal issues are going to be the same. That contract is going to have a basal level of sophistication once you enter the commercial lease avenue, whether the space is 400 square feet or one of the latest commercial leases we negotiated was for hundreds of thousands of square feet. If you're new to the channel, welcome. My name is Pamela Metani. I'm a business lawyer and the founder here at Graphene Business Law, a law firm working exclusively with entrepreneurs and serving these clients virtually all over the province of Ontario, Canada. If you're new to our YouTube channel, go ahead and give this video a thumbs up and click on the subscribe button down below. Slowly but surely, our subscriber count is steadily growing, and I'm so proud of this small community of knowledge and information and just support we've created here on YouTube. And of course, one of the best ways to keep that going is through you subscribing, liking, commenting, because you might be able to help others in the same situation, or if you have a question yourself, others might be able to help you. So when it comes to the topic of commercial leases, we've posted out one of the first videos ever on this channel, and it's so funny looking back at those videos now that the channel has grown, but one of our first videos ever was on commercial leases. This was at the peak, or the beginning of the peak, I should say, of COVID-19, so maybe early 2020, something like that. And the video was a really short 1 or 2 minute. We didn't do as much long form content back then on the different kinds of commercial leases, being single, double, triple net, and single, double, and triple net leases generally in the commercial space. And what that means, big picture, the more that net count goes up, so single, double, triple, with triple being the highest, the more you as a tenant will be responsible for. This video is going outside of that scope of the very, very basic commercial lease content, although let us know if you'd be interested in seeing a video like that and talking about contentious and dangerous clauses specifically. So we're not going over every clause, and we're not going over the obvious clauses that you're going to find in a commercial lease, and in a commercial lease, including of course dollars per square foot, you know, how many square feet, location, things like that. That goes without saying that you should be seeing that in a commercial lease. And of course, you should only be signing if it's something that you're comfortable with and understanding those terms. And again, here at Graphene Business Law, very, very well experienced in helping you navigate commercial leases of all sorts. So again, the 3 contentious areas I want to focus on in this video for the purpose of a digestible YouTube video go as follows. The first clause I want to talk about that you should keep an eye on is repairs, okay? Repairs are one of the main topics, or can be one of the main danger topics of a commercial lease, that tenants who didn't know what they were signing or didn't take the time to ask questions as to what they were signing of their lawyer, or maybe made the mistake of not even hiring a lawyer when signing onto a commercial lease, which is, by the way, a really, really big mistake, because commercial leases can be very lengthy. Residential leases, you see them for 3 months, 6 months, 12 months. Commercial leases on average are like 5 to 10 year commitments. It's a different ball game when the landlord owes you much less responsibilities, much less tenant friendly than individual or residential leases that we see in some jurisdictions in Canada, including of course Ontario, where Graphene Business Law practices. So the repairs topic, that's a topic where if we're getting clients coming to us, not in the negotiation stages of commercial lease, but in the issue stages, so they've already signed, as I mentioned, made some bad deal in signing, and now the issues are coming up. Now the reason that they needed a lawyer in the first place is coming up. Repairs is one of them. Repairs can range from anything, including the most trivial, substantial, silly examples of light fixtures, things like that. But also, you know, as you can imagine, the more contentious, dangerous, costly a repair becomes, the more likely that a client is going to be to seek out a lawyer, because there's so much more at stake for them. A classic example would be, you know, roof issues, especially in a place like Ontario, Canada, with all the snow and the rain and the wear and tear that happens to these roofs, can be tremendous. If your roof falls in, you, chances are, can't carry out your business. So roof repairs. Another one is plumbing. Plumbing, of course, goes hand in hand with electrical. All of these issues. Is your contract crystal clear to you on whose responsibility it is to financially cover these repairs? If it's clear, what is your understanding of what that clear language says? Is it your responsibility or is it the landlord's? Are there dollar caps there so the landlord can repair up to X amount of value and then the tenant takes on the rest? Or the tenant goes through their insurance first and then the landlord covers the rest? Or the landlord does nothing? What is the arrangement there for these repairs? Depending on the size of your business, the cost of these repairs can be tremendous. As you can imagine, a roof on an industrial or commercial space of, you know, 50,000 square feet is going to cost more than some houses in some cities. But also, regardless of the dollar value of the repair itself, every time, even if your business is a 100 square foot hut, a business without a roof in Canada is not going to be a viable one, so long as it's a store, like physical business. Obviously, we're not talking about the world of remote practicing here, because then why would the roof, you know, be an issue? So, and why would you have a lease in the first place, by the way? But in the world of the physical, there are certain repairs. Again, I mentioned at the beginning, danger, right? Like when you look up on Google dangerous clauses of commercial lease agreements, or what to look out for, or you Google what to look out for in a commercial lease agreement, you know, in Ontario or generally, I hope, I don't know if there'll be a day when this article, you know, comes up on top, or this video comes up on top on Google, but I hope so that you can really focus in and appreciate the risk associated with not understanding the details behind some of these clauses. And again, repairs is a tremendous one and can range from anything from a light fixture all the way to big ones. Roof, we see a lot, especially in our freezing cold jurisdiction. Plumbing, electrical, heating, furnace, things like that. Who is taking care of these? What about, you know, things you might not think about, like your sign falls down and now it's hanging sideways, so obviously your business looks like a loser shop. Who's going to come to a business that can't even take care of its own sign? Who's repairing that? You need to ask. You cannot assume. You cannot sign something and assume, because if you are leaving yourself to that position of assuming it will be worked out, almost always it will work against you, because why would the landlord have left that loophole in the contract and not looked out for themselves? The only assumption is that everybody looks out for themselves, and if you don't ask, you have no idea what you're actually signing. So make sure you understand. And again, here at Graphene Business Law, we can really help you not only understand but negotiate to better your position with these commercial leases, because it's not, there's no standard language. It truly depends on your interests and your power dynamic with the landlord, and you know, all of these sorts of variable factors. There's no one size fits language when it comes to commercial leases, for all the obvious reasons that, you know, we've already mentioned: size, geography, complexity of the space, complexity of the business. You know, do you sell unfold t-shirts in the back, or are you running like steaming factory, you know, machinery and equipment in a contentious space, in an environmentally tricky location, things like that. So repairs is the first thing you're going to want to make sure you really understand. And there is no business that repairs would not be an issue for. Even the person folding 50 white t-shirts in the background is still going to have, you're going to be able to do that without a roof? Won't your inventory get affected? Everybody will suffer on the commercial tenant front if you are not, you can only suffer on the commercial tenant front if repairs to your physical business are not taken care of, for, again, obvious reasons, you know, exposed to the elements, no lights on, no water, things like that. The second danger spot you should look out for. And again, this is not a list of 3 out of 3. This is an introduction to that world of clauses you should look out for in commercial leases, signing on as a commercial tenant. Although if you're a landlord watching this video, of course we work with landlords as well here at Graphene Business Law, and you know, this knowledge will undoubtedly be helpful to you as well. But the second thing is going to be maintenance, not to be mistaken with repairs, right? Repairs, hopefully your roof isn't caving in every first of the month, so it's like a maintenance issue or regular issue to be dealt with. The difference between maintenance and repairs is that repairs are generally more of a one-time, every now and then cost, but when they come, they're really high ticket items, whereas maintenance is an expected cost. Any person in Ontario watching a video talking about maintenance, what's the first thing that came to your mind? Snow care. It sounds silly, you know, you picture yourself with a shovel and a toque on, but no, snow care can cost tens of thousands of dollars a year in maintenance, depending on the size of your spot. If you're renting out a shopping plaza, if you're a commercial tenant, you know, an anchor store in a commercial plaza, your maintenance is going to be extraordinarily expensive on snow care every month. You're going to have dozens, if not hundreds of parking spots. You're going to have cracks in the parking lot that come with associated costs and this and that. Spring and summer still do come in Ontario, by the way, right? The weather does warm up at some point. So what about the lawn care, the garden care, things like that? What about the care that's sort of, you know, between the sky where the snow's falling from and the ground where the grass grows from? Trees, hanging trees. Do you want to get hit with a lawsuit because a client on your property that you rent got hit, you know, by a branch in the eye and get sued for tens or hundreds of thousands of dollars? Probably not, but whose responsibility is it to cut down those branches? These are all maintenance items that can be very high ticket items, not only as regards the taking care of them, but also in law, we have to think about what could happen, right? What could happen if we don't take care of this? So these are high ticket items on the flip side of you not taking care of them. You can get sued for hundreds of thousands, for millions of dollars. Somebody slips, gets badly injured on ice on your property. Somebody gets hit by a branch in the head that was obviously dangling and should have been taken care of. You know, all of these things between sky and floor, so to speak, that are expected, seasonal, annual, whatever the case may be items. Who is covering them in your commercial lease contract? Do you understand who's covering them? And are you comfortable with what you understand about who's covering them? Okay, because it's one thing to be like, this says tenant covers everything. And it's another thing to say, you know, I don't know if I'm comfortable with that. Can the landlord really not help out with any of these costs? We both have a benefit in, you know, the grass being upkept, for example, because we both have a better looking property that draws in more clients. The more clients I get, the more money and more stable money he gets from me as a landlord. Same with the snow care. If there's a snowbank and you can only have one car parked in a parking lot of 100 cars, well, you're not going to be able to pay your rent very soon because 1% of the business you were otherwise getting is likely not going to be enough to sustain your business financially. But doesn't your landlord have an interest in you paying your bills? So maybe they can help with the snow care as well. The third danger clause I want to talk about in this video, again, for the purpose of keeping it digestible, not 3 out of 3, 3 out of many, is going to be the exit clauses, so to speak. We saw during COVID that very successful businesses had to shut down. But those businesses prior to COVID had still signed leases for an average of 5, 10, or even more years. There are 99-year leases in business, okay? And there's certainly 10 and 20 and 25-year leases. So if you are 2-3 years into a lease, do you go bankrupt, you know, because you cannot pay the remaining 23 years? You can't pay another 23 days. That's why you're shutting down business. What happens with that gap? Do you have to find a subtenant? What happens if you can't? What if you have personal circumstances? You have to leave the country, you have health issues. If you're the sole person of your business, Kevin O'Leary on Shark Tank always says that he's reluctant to invest in businesses where if the owner gets hit by a bus, there's no more business left. Well, what if you as an owner get hit by a bus? You can't show up to work anymore, but your work is constructed in such a way that, you know, everybody, the whole setup depends on you instructing others on what to do. If you can't go to work, you can't instruct others on what to do, business shuts down, but you still sign a lease. What are those emergency exit options for you in that lease? If you're in a 5-year lease, do you have an option to maybe cancel out with 1 year payment. I know it sounds crazy paying a year for nothing, but a lot of the times in leases we see that a commercial tenant is actually liable for the remainder of the lease if they don't find another subtenant, or if they for whatever reason need to terminate their commercial lease. Commercial leases can be ruthless when it comes to how tenants are dealt with in these same commercial leases. Landlords do have a lot more power, including for the obvious reality that you're looking for a space. They already have one to rent. You're the one that needs one to carry out your business. It's a lot more complicated than that, but just giving a high-level overview as to what's one reason things could be so one-sided. Commercial tenants, on average, also tend to be very sophisticated parties. They're parties with money, so they can, afford to influence certain outcomes in their favor. And I'm not talking about anything illegal or fishy or whatever. It's just a reality. Who writes the textbooks, the winners or the losers are writing from their grave, right? In the world of commercial tenancies, the landlords have kind of already won to be able to have a space to rent out to a commercial tenant that many potential commercial tenants want to apply and pay them money for. I hope this video was helpful. Let me know what you thought. Let me know if you are just about to sign on to a commercial lease and there's certain clauses that you wish you had more information on. Let me know if you've already signed one in the past and you had certain lessons in signing that lease, certain things you wish you had known prior to signing, and what clauses that pertain to. Of course, without revealing anything confidential or anything weird, just in general, anything that exposes you to any sort of risk. Just speaking in general, I wish I'd known that you could be liable for this. I wish, what have you learned through your firsthand experience with commercial leases as a small business owner? As always, thank you so much for watching. Again, don't forget to give this video a big like and click subscribe down below. If you are a small business owner anywhere in Ontario, we can help you virtually in negotiating your commercial lease and our website is graphenebusinesslaw.ca, and our welcome email address is info@graphenebusinesslaw.ca. Thank you so much for watching.